Alright. Jumpa lagi.
Good. Next time we must be on the same side again.
Yeah, that's right.
After the rally.
See you.
Huh? After
The rally.
Okay, you can.
Okay, you can
What do I do?
explain the judgment.
Oh, I think we won we succeeded in the opposing successfully the application of the plaintiffs on a variety of grounds. First is there does not seem to be any authority given to the plaintiffs to bring the action on behalf of the organization. There's a technical rule. But also it is for the police, not for this group of people, private group of people, to prevent the exercise of a constitutional right to peaceful assembly. The Peaceful Assembly Act is there, and it is for the police to regulate, as they have been regulating all this while. They can impose conditions, we can even appeal against the conditions, we can even challenge if they impose conditions which are very onerous. That's what the law says. And then the court agreed with us. They also agreed that they also remarked that, we are on common ground. Both the red shirts and the yellow shirts are on common ground in opposing this application, because we all want to exercise our constitutional right. And importantly, it is for the police. They have the power to order any counter rally to be relocated to a different place, even a different date and a different time. I think this under Section 18 of the Peaceful Assembly Act. So the power should be with the police, not a group of people trying to stop the assembly from proceeding. So these were basically the main grounds.
Oh, and delay as well, actually.
Yeah. And also they knew since September that this was going on. Now when all the preparations are being finalized, the logistics, the expenses, they come at the very last minute, the 11th hour, the court said, to try to stop the rally from going on. The court said that you knew about it 2 months ago, everybody knows. Why come at this late hour?
One of the things that the judge actually mentioned in his judgment was Section 18 of the Peaceful Assembly Act, which is what we have been saying, Bersih has been saying, Maria has been talking about, we've all been talking about. And he recognized that that is an option for the police to take, or the judgment certainly seems to say that, suggest that. And in fact, interestingly, the red shirt, the counsel for the red shirts actually said that if the police directed them to do their rally in another place, they would consider it. So in that case, I think it would be very wise for the police to actually take them up on that.
Yeah. And another thing the judge said is that Section 18 is actually a safety valve.
Yeah.
To diffuse
That's right.
The situation if there is any possibility of any conflict. So that is a very useful pronouncement by this court on Section 18. I believe it's the first time that a court has considered Section 18, and it reminds the police actually of a power that they already have. So all this concern by various bodies that is going to result in clash and so on and so forth, even by people in very high authority, right up to today, is actually not the case, because the police have ample powers. Section 18 is very clear, as Ambiga has mentioned, to diffuse the situation, and the court has recognized this, and we hope now the authorities will begin to act on this provision.
We appreciate the traders' concern, but if you look at the Bersih 4, I don't think it really have affected the businesses, because everybody was actually doing a roaring business. Under the Peaceful Assembly Act, there is no need for permit, and there is no need for the police to actually give us permission, as long as we fulfill the requirements. And we did. We gave them the notice to let them know where the route is coming from and what day and what time. So we have fulfilled our duty, and we look forward to working with the police as what we have done in Bersih 4 for a peaceful rally.